That's another open question as to when. Let's assume for now that the court does indeed overturn the Quill doctrine. The next question is, well, how will they do it, and how will that be organized? Really, what was interesting is that all the legislative attempts that never went very far to override Quill had a very clear plan and a timeline as to what states would need to do in order to apply Nexus based on economic standards, and when they could do it under what timeline. I don't know what's going to happen in the context of this court decision. What's interesting is that there are at least a couple of states that have these rules that are either in direct legal challenge, much like South Dakota, except they're not as far along, or they have rules that have baked into the law that said this rule becomes effective the moment the Supreme Court makes a decision that overturns the Quill doctrine. So in other words, they wrote into their law, we have this law taxing remote commerce, but we're not going to enforce it until the court says we're allowed to. So really what's an interesting question is, well, what will the court say in their opinion about these laws and about states' ability to enact economic nexus rules? Will it be at the Wild West? Will states be able to do what they want when they want it? Or will the court in some way kick it back to Congress and ask them, again, to articulate a standard as to what would be the necessary predicate actions to allow a state to enact an economic nexus rule? So really it's a wide open question, and probably one of the most interesting questions as we look forward to a Supreme Court decision on this case.